Good morning.
Good morning, Your Excellency.
Morning, Your Excellency.
I don't hear Mr. Tom.
Can you hear us now? Good
Yes,
morning.
I hear now. Good morning. Okay, if we are ready, let's start.
Fantastic.
History. Do we need to call out or maybe just continue? I think we don't need to call out. I think we just go ahead. Please go ahead, Mr.
Okay.
Yeah.
Certainly. Thank you, Your Excellency. So today is my client's, OIC's, application for permission to appeal. I just wanted to check again that Your Excellency had both the core PTA bundle, and there is one document that I'm referring to from the trial bundle. So I don't know if you have access to that as well.
Yes, I should have.
Fantastic. Now, I set out yesterday some key points concerning appeals, and I of course accept that they apply equally to my application for permission to appeal. So I won't waste any of the court's time in repeating those. But in brief, what we say is that all I need to do is establish that my grounds of appeal have a real prospect of success. And whilst on pure factual matters or factual inferences, I would need to show that Your Excellency's decision was plainly wrong. I need show no such thing on points of law or points of on the interpretation of documents, which, as I discussed yesterday, are either to be considered as pure points of law or mixed points of fact and law. And for these, I only need to show more than arguability, a realistic as opposed to a fanciful prospect of success. I put an extract in my skeleton argument from a judgment of Justice Giles in Datani and Damak at paragraph 6. And we say that on that basis, the hurdle is low. We need only show that there's arguability that a different interpretation or conclusion would be reached by the Court of Appeal. And finally, as I'm sure Your Excellency will have in mind, I don't need to persuade you today that I'm in fact right on any of these points, and that follows from that test. And we accept you have, of course, on the points I'm seeking to appeal, already found otherwise in the judgment. And just as Mr. Montague-Smith made clear yesterday, we wish to make clear that, of course, we entirely respect and are grateful for Your Excellency's careful judgment. What we do say, though, is that for today's purposes, we do meet that test of our grounds of appeal being more than merely arguable, and we say we do so for each of those grounds. Now, Your Excellency, I wonder
just sorry to interrupt, just now came to my mind. Are there any kind of agreement, if you're not agreement, but are they ground for appeal which is similar by both parties in this two application?
Well, we both have appeals on questions of certainty, but the nature of those appeals on
nature is different. But so what I was looking for, if both parties found that I went wrong in the specific point with on the similar issue, but seems to me each party may be thinking I was wrong in certain point, but in different way or different analysis. But there is no similarity in terms of ground for appeal for the same point. So in that matter, then I have to give permission to appeal in that particular issue. So this is something just came to my mind right now, but I think I was wrong.
No, of course, Your Excellency.
Please, Tom. Yeah.
I was just going to say, I mean, for my part, I don't see that there's an overlap where we are both saying that this a particular part of Your Excellency's judgment is wrong.
Yeah. Okay. All right. Thank you. Yeah. Sorry to interrupt. I just want to be in the same.
No, not at all. Not at all.
All right.
So, Your Excellency, I wonder if it might assist if we turn to page 99 of the permission to appeal bundle, which is my client's grounds of appeal.
Yes.
And we can see there that there are 5 grounds in total, but I propose to group them as follows. And Your Excellency will hopefully be pleased to hear that means me addressing fewer topics because I think they can be grouped. The first ground is the nullity appeal, and this is on page 99. It's grounds 1, which has subgrounds 1.1 and 1.2. And by this, we challenge the first and second declarations that GlobeMed is a valid company and that the TPA agreement is a valid contract. The second ground that I will address, bless you, Your Excellency, the second ground I will address are grounds 2 and 3, which go to questions of certainty of loss. The third ground is ground 4, which challenges Your Excellency's finding that there is to be no reduction of 51% of any damages due to GMG because of the intended shareholding structure. And then finally, there'll be a very brief word on costs. Now, what we say about costs, and I'll mention it only very briefly, again at the end, we can largely get it out of the way now, is that it is entirely parasitic in our grounds of appeal on the other grounds. As indicated yesterday, we don't take any issue with your costs order in the context of the findings that Your Excellency reached. We simply say that if some of the points are overturned in our favour, then costs follow. And there are two schools of thought on this as to whether that needs to be included as a ground of appeal or not. And I think in order to be safest, we did include that as a ground of appeal. But that isn't something that is separate or independent. We say that simply follows if we are granted and then granted permission to appeal and then are successful on any of those permissions. Now, so with that aside, that means there are really only 3 topics that need to be covered today. Nullity is the major one. It's the one that's going to take the most time, and it's the one on which I'm focusing most of my fire. There are more issues in that than there are in the others. And then it's going to be followed by certainty, and then the 51% reduction point, both of which are much shorter. So starting then with nullity, at the outset we say, and we note that GlobeMed doesn't appear to suggest otherwise on this ground, that this ground is one which relies only on the interpretation of documents and points of law. So in other words, the matters which it addresses are, in the ordinary course of things, the type of matters which are eminently appealable. And we say that permission should be given because we have at least an arguable case on each of those points. In brief, we say that the judgment was wrong first in its interpretation of the side agreement, in particular in finding that it was non-binding, relatedly that it didn't amount to a waiver of profit or shares, and that it didn't have the impact of invalidating the company contract. Second, we say that the court was wrong not to find that if GlobeMed is invalid and is a nullity, then there is no claim in these proceedings on the TPA agreement. And I'll take each of those points in turn. And I stress that the points I make now are by way of points of general observation in order, I hope, to persuade Your Excellency that we have a real prospect of success. This is not my complete appeal, as it were. I've got more points in my bag if I need them, when hopefully for us the time comes. Now, so just to recap, Your Excellency found that the side agreement was non-binding, didn't amount to a waiver of shares or profits, and didn't have the impact of invalidating the company. So taking each of those points in turn, which go to ground 1.1. First of all, we say that when one looks at the side agreement, it is something that clearly looks like a binding contract. And it might be useful at this point to turn up the side agreement, which is at page 291.
Yes, 291.
I'm grateful. And the first point we make is, we say, a pretty straightforward, pretty obvious point, and that is that it's headed agreement. And we say that the fact that the parties have chosen to call this an agreement is a strong indicator that it is just that. And we say that it would be odd to call a document an agreement if it were intended to be non-binding. That is the language we say of contract. Second, we say that beyond that, it also has all of the hallmarkings of a binding agreement. It identifies parties. It has a preamble, which for these purposes at clause 1, it then incorporates as an integral part of the agreement. It has various clauses that are listed. So it looks like an agreement. It's called an agreement. Third, we say that it is relevant that at 292, the introduction to the clauses of the agreement are headed, "The parties have agreed as follows." So clearly we say the parties were intending to record by that what they had agreed in a binding sense. Fourth, the definition of the agreement in clause 2 is the current partners agreement. And again, that suggests not only that it is an agreement, but that it is an agreement between the partners. And second, that it's current. And by current, we mean current in relation to the company contract. And we say that's what the parties meant by it. So it was an effective agreement. It was one that was in force because it was current. Fifth, we say that clause 3 provides that the parties agreed that the provisions of the current agreement shall apply to the current partners in the company. And shall is mandatory.
Just sorry to interrupt, just to further, of course you know that, but this has been translated from original language Arabic to English.
Yes,
so
that's right.
Saying that those words sometimes it's not necessary to be the original words, and the meaning will be might different.
Well, Your Excellency, we have two translations in the bundle. I suppose my point is that the points can be made similarly with either translation, and it's the language of contract. I appreciate that if there are important linguistic differences, then no doubt my learned friend will point to those in the different translations, and I can perhaps reply. But of course, we at this stage are required to look at the English translations as a matter of the evidence in this court. But perhaps if my learned friend has points on differences in translation, I can respond to those in reply.
Sure, always.
Thank you. So we say clause 3 provides that the parties agreed that the provisions of the current agreement shall apply to the current partners in the company. So again, we say that is mandatory language that the parties use to bind themselves. Sixth, we say at clause 4, and also at clause 6 and clause 10, it uses the language of a party undertaking. And again, we say that that is mandatory language, that is binding contractual language. Clause 10, of course, is particularly relevant because that's where Mr. L.L.C agrees or undertakes to waive his profits. Seventh, we say that clause 12, and I'm now on pages 294 to 295, uses the languages of declares and pledge. And again, we say that's promissory, that's contractual language. Eighth, at clause 20, it has an arbitration clause. And we say that an arbitration clause would be completely unnecessary in an agreement that was non-binding, because the whole point of an arbitration clause is to settle disputes. And there couldn't be a dispute. There couldn't be a dispute that needs settlement by a dispute resolution mechanism if this wasn't intended to create enforceable rights, because otherwise there would be nothing to enforce by way of the arbitration. Ninth, we say that clause 22 is such that it shows that the side agreement is and was intended to be valid and enforceable. And we know that because it says that to the extent that any part of it is invalid due to its violation of law, this agreement shall remain valid and enforceable. So clearly the parties thought that by default, unless something happened to change it, it was valid and enforceable. And then finally, of course, one can see that it is signed and witnessed. And just like my first point concerning the heading of it as an agreement and the fact it calls itself an agreement, one would be, or it would be surprising to see something signed and witnessed in a formal way, unless it was in fact intended to create binding rights. Now, we have those 10 points as to why we say on an analysis, that document is clearly intended to be a binding document because it looks and it talks and it behaves as a binding document. To resurrect the creatures analogies, there's the famous saying about a duck, that if it looks like a duck and quacks like a duck and walks like a duck, it probably is a duck. And we say that that can be applied here without any rabbits in sight, of course, Your Excellency. So we say that against all of that, there really is one point that points the other way, and that is the point that GLOBEMED puts great stock in and that Your Excellency referred to in the judgment, which is clause 24. Now, the question is what clause 24 seeks to do, and it's the last sentence of clause 24 that GLOBEMED rely on, which notes that consequently this agreement may not be considered defined or interpreted in any case as an actual contract between the parties. Now, what we say is that that sentence has to be read with the first sentence, which is essentially acknowledging that the parties know and appreciate the sham of what is being done, because the first part of that notes that Mr. L.L.C is a partner for the mere purposes of incorporation, not as an actual partner. Now, as an aside, we did not understand, we have to say, the reference to mere purposes in the same way that Your Excellency did. In the judgment, of course, Your Excellency found that mere purposes, or considered that mere purposes, meant that there was an attempt to suggest minimal compliance, so the bare necessary. But we understand in its context, we say that there's another reading of that, which is that mere simply means that in essence it was recognised that the only reason that Mr. L.L.C was identified as a partner was to present this false front to the world for the purposes of incorporation only. So it was, in essence, the facade that was shown to the public that he was in fact a partner. So the mere facade, but in all other purposes and for all other reasons, he was not an actual partner. And we say that interpreted in that way, and we say that's a perfectly reasonable interpretation, certainly one that the Court of Appeal will consider as a possible reasonable interpretation. That then makes sense of the second sentence, which shows in those circumstances that the parties knew what they were doing. And so in essence, what they were saying was that because we appreciate that what we are doing is contrary to the law, we will say that this is an agreement which is not to be considered an actual contract. But we say that that, aside, as it were, in clause 24, doesn't do enough to overcome all of the other points that we've made of the fact that clearly on an interpretation there are, we say, clear indications here for the purposes of today, clear indications that the parties did intend to bind themselves by this agreement. And certainly, I suppose, to think of it another way for today's purposes, if somebody had breached this contract, if, say, Mr. L.L.C had attempted to take profits, or if, for instance, the payment hadn't been made on an annual basis against fixed profits, would this court simply have slung the case out and said, well, there's no actual contract here, there's nothing for you to sue on? And we say, no, not of course not. This court would consider that claim. It's not a claim that would be defeated on a summary judgment application. It's a claim that the court would entertain and would hear. And we say that's enough for today's purposes for granting permission to appeal. Now, we say, however, that in this case, that is not the end of it. And this is, I'm afraid, Your Excellency, where I have to take you into the trial bundle, which I know is an enormous bundle. The relevant document is at page 1696. And Your Excellency may well remember this document. It was something that was referred to in our opening skeleton and it was relied on at trial. But this is, again, the translation. And if Your Excellency wants to see the original, it's at the next page, page 1697, of a letter that was written from Mr. L.L.C to GLOBEMED Limited and was signed in approval by Mr. Karma of GLOBEMED Limited. And materially, for the purposes of this permission to appeal, this letter provides that we hereby acknowledge that our possession, and for some reason it's translated as our, but it must be my because it's coming from Mr. Al-Helu. We hereby acknowledge that my possession of 25,500 shares of the said company has been made for your account, i.e. GlobeMed's account, and that our possession of these shares is on trust and on your behalf. We do not have the right to dispose of, transfer, forfeit, or use them as a guarantee in any way. Thus, we do not have any acquired or other rights to dispose of these shares to any other person or third party. And then finally, at the last substantive paragraph, accordingly, we hereby finally, completely, and irrevocably waive these shares to GlobeMed Limited. So we say that this absolutely backs up what we are saying about the side agreement. It makes absolutely clear, and it couldn't be plainer, that what the parties were intending was that Mr. Al-Helu did not have any rights in the shares. And he's made that as clear as can be possible in this letter. And we say that that's something that should be taken into account when one is analysing the effect of the side agreement. There is also, going back to the permission to appeal bundle at page 268, statements in the MOU. Now, I appreciate that the points that I took against Mr. Montague-Smith yesterday apply equally as against me. And yesterday, of course, the point I made was that the MOU was an agreement between different parties. Mr. Montague-Smith said, well, you can still look to it in order to see what those parties thought the agreements were. I say that's right. I say, just as in the context of yesterday, one can't put too much weight on it, but it is relevant, it is informative, and it is background. And we can see that in the preamble at 2, the parties, which of course include GlobeMed, so one of the parties to the side agreement, sets out what they think the effect of that side agreement is. And we can see there that it says that Mr. Adel Ibrahim Al-Helu, UA national passport number, owns 51% of the shares in GMGHS on behalf of GlobeMed, based on a side agreement signed between GlobeMed and Mr. Adel Ibrahim Al-Helu, and the waiver of shares document, so I think that's a reference to the letter, signed by Mr. Adel Ibrahim Al-Helu in favour of GlobeMed, whereby GlobeMed owns effectively 91.05% of the shares in GMGHS. So again, we say this is another indication that the interpretation that we say there is to be of the side agreement is a correct interpretation. It is, in other words, intended to be an agreement that creates rights, that dictates what the position is as between those parties as to profit and shares. So that then takes me to my second point, which is, did the side agreement amount to a waiver of profit or shares? And again, Your Excellency found that it did not. And that, I think, Your Excellency, was primarily on the basis that the side agreement was not binding. So we say that if we're right about my first point, then the second point rather falls away, because the language of the side agreement is clear, that what the parties intended to do was to waive their rights in shares and profits. We say that that is clear, and if one goes back to the side agreement at 296, back a little more, at clause 10 is in relation to profits. The first party undertakes to waive his profits in the company. Clause 12, the first party declares that he does not own any share or percentage in the company's tangible or intangible assets, or in its company, or that is deemed as part of the company's assets, which entirely belongs to the second partner exclusively. And then, in addition, the first party has pledged in advance not to claim any share of any kind from amongst the company's assets and capital. And we also have the preamble, of course, which notes that the formal distribution, as it's referred to, does not reflect the actual partnership between the parties. So we say, if I'm right about the side agreement being intended to be binding, then we say the language of the side agreement is clear that it does amount to a waiver of shares or profits. But we also have an alternative argument, which is that we say even if the side agreement is not strictly binding, as Your Excellency found, then it's still evidence, strong evidence on a proper interpretation of the document that reveals the sham of the company contract. And hence we say it proves the nullity of the company. And we say it's relevant that the UAE case law shows that proof of a sham can be done by all means of proof. And this, for instance, is made clear in the Dubai Court of Cassation decision 330 of 2000, which is at page 875 of the bundle. One can see in the third paragraph there, that it said that this being the case, a third party, and we say that's us, a third party, may seek to establish by all possible means of evidence that a company's MOA is based on the circumvention of law and is intended to harm its interests and finally establish its voidance. So we say that this is evidence of that kind. It is a document which can be interpreted on its face, which shows that what is said to be the case in the company contract is not so. Now, GLOBEMED's answer to that is to rely on a decision of the Union Supreme Court, and that is at page 1301 in translation. And they suggest that this shows or requires that what is required is a binding contract. But we say when one looks at this, it shows no such thing. Here it says it's well settled that fictitiousness is proven when the parties to the contract agree to hide their transactions and real legal positions in an apparent contract that has been executed to be a front for their dealings with the public in the presence of a letter or agreement that is in force between them. Now, there are two things which arise from that. First, we say that this doesn't suggest that there has to be a binding contract between them, because a distinction is drawn in this case between an agreement, which we say, just as I submitted now, might ordinarily be considered without more to be binding, and a letter. And we say a letter would ordinarily not be considered to be binding. So we say that the reference to the distinction between an agreement or a letter undermines the point that GLOBEMED is trying to make. The second point we say is that this merely shows that it has to be in force between them. So in other words, current. It has to be the thing that is applicable between them. We say that in force is not necessarily, in this context, synonymous with it being binding. We say it's different. It merely has to be relevant as between them. So the other thing that we point out, which is relevant to a point I will make next, is that we say that this case shows that contrary to the submissions made by GLOBEMED, the agreement in breach of the profit and the ownership requirements doesn't need to be in the company contract itself, because it simply needs to render the company contract a front for their dealings. Now, it wouldn't be right and it wouldn't make sense to talk about the company contract being the front for the dealings and the true relationship to be in the background, if in fact it was always a requirement that the offending provisions had to be in the company contract. Because the company contract wouldn't then be a front, the company contract would itself be in breach. So we say that this case also, in fact, makes clear what we have been submitting, which is that it's not necessary for the offending agreement to be in the company contract itself. But either way, we say that the side agreement in the preamble and at clauses 10 to 12, which I just took Your Excellency to, explicitly say that profits and shares and the rights in profits and shares are waived by Mr. L.L.C. Now, what's said against this, as I understand it, Your Excellency, is that in the agreement, the shares are referred to as his shares in relation to Mr. L.L.C. Now, we say that that reference to his shares is clearly, and we say heavily outweighed by, for instance, the share waiver letter, which absolutely and clearly shows that Mr. L.L.C finally, completely and irrevocably waives the shares to GLOBEMED Limited. But in any event, even without reference to that waiver letter, we say that his shares is just a reference to the formal distribution. It's not a reference to the actual partnership, as the parties have referred to it. So it's shorthand merely for identifying the shares which Mr. L.L.C purports to hold. And that, we say, is the only sensible way to interpret the reference to his shares in the contract. And certainly, we say, it is a sensible interpretation, which is very clearly and clears by some margin the hurdle of it being more than merely arguable. Now, another point that's taken is the suggestion that because the side agreement at clause 10, and it might help if we go back to that, that's at page 294, is that because the side agreement at clause 10 stipulates a sum for breach of requirements to waive profits, this is not a true waiver. Now, that was a point that we understood Your Excellency to be making. GLOBEMED, I think, to some extent, disclaims that point in their skeleton, but just in case it is live and it is relevant, we address it anyway. We say that the fact that there is a sum that is identified to be paid in the event of breach doesn't mean that there is, in essence, an option on the obligor as to whether to offer or not offer performance. And just as a very brief aside, Your Excellency, as well, I just note that Mr. Montague-Smith's submissions yesterday suggested that I was leading the court down a very dangerous path in suggesting that not all damages awards involved counterfactuals. This is an example in the papers before us of an award of damages that wouldn't require a counterfactual because there is a specified sum, and that was one of the points I was making. But nevertheless, back to the matter at hand, we say that it isn't right to suggest that if there is a specified award of damages that results because of breach, that in essence the obliger has a choice as to whether they offer performance or pay the damages. And one can see this clearly said in Al-Sanhuri, in the Al-Wasat at 1390 of the PTA bundle, and it's paragraph 487. And the relevant part starts in the second sentence after the colon. And it says there that the debtor is obligated to fulfill the principal obligation for the creditor, but the creditor may demand the enforcement of the penalty clause and the debtor may fulfill it for the creditor if the performance of the principal obligation becomes impossible due to the fault of the debtor. So it isn't the case that just because there is a sum specified that Mr. L.L.C could choose to pay that sum. That isn't right. As a matter of analysis, he's still obligated to fill the principal obligation, which is the waiver of profit. So we say that that point doesn't militate against the clear language of the contract. Now, GLOBEMED make a further point in relation to this in their skeleton, to the extent that it's somehow relevant because it's a promise to do something in the future. Now, I must confess, I'm not sure I follow this point. It seems a little confused and confusing, but if Mr. Montague-Smith clarifies it, then I might be able to reply to it. But insofar as what's being said is that it's a promise to do something in the future, and therefore it's not a breach, well, we say that's irrelevant because, of course, this is an agreement which is intended to be forward-looking. It's intended to say what will happen with profits in this company in the future. And Mr. L.L.C has bound himself as to what to do in the future. So we say that if one is looking at this for the purpose of saying, well, has he agreed to waive his profits? Then we say absolutely yes. It would be, we say, nonsensical, if that's the point that is in fact being made, to say that it has to be some sort of agreement to do something at the time when the profits come about, because of course that would just require a new agreement every time. And that isn't, we say, a realistic scenario. But as I say, Mr. Montague-Smith clarifies that point, perhaps I can reply to it. So that then brings me on to the third point that arises in ground 1.1, which is, did the side agreement have the effect of invalidating the company contract? And we say the answer to that is yes, because the sham is what must be in the company contract. And the sham, we say, as I noted earlier, can be revealed by any means of evidence. So the side agreement, the letter. And we say that that fact is made clear in the case that I referred to above, that GLOBEMED relies on, of the Union Supreme Court, and also the more recent case, the Dubai Court of Cassation 585/2023, which I deal with in my skeleton. It's also, we say, clear from the Cafe Rider case that was before Your Excellency. That is at page 1315 of the relevant section is at page 1315 of the permission to appeal bundle. And just in the first block of text, after the definition in black brackets of the Cafe Rider L.L.C, it said the unavailability of objective elements of a limited liability company by partners' confirmation, contrary to what is confirmed in the Memorandum of Association, entails its absolute invalidity, which is related to the common law and decided by the court autonomously. So what that is saying is that the confirmation must be contrary to what is confirmed in the Memorandum of Association. Of course, if the confirmation was always in the Memorandum of Association, then it wouldn't be right to talk about the confirmation being contrary to the Memorandum of Association, because the Memorandum of Association itself would always be the thing that breached the law. So we say that it was wrong to require that the agreement be in the company contract itself. But even if I'm wrong on that, we have a further point, which is we say to the extent that it's required, we say the side agreement can amount to something that might be referred to as an addendum to the company contract, because it clearly states that it seeks to vary the position in the company contract by, for instance, providing that the actual partnership between the parties is determined under the current agreement. And that is one of the extracts I referred Your Excellency to. It's at page 292. And it also refers to the side agreement as the current partners agreement. So clearly what it's intending to do is vary the position as it is in the company contract. And in that sense, we say that if one were to talk of it as being an addendum to the company contract, that would be perfectly faithful to that, because it is intended to change the rights of the parties as they are set out in the company contract. Now, even if I'm wrong on that, we have a final and yet further point, which is that we say that GLOBEMED only seem to argue, and this is paragraphs 49(1) and 2 of their 44(14) response, that it is the profit requirement that must be in the company contract. They say nothing about the ownership requirement. And of course, we rely on both. So we say, Your Excellency, that for those reasons, the side agreement should have been interpreted as a binding contract. We say that when it's viewed as such, it clearly does intend to waive profit and shares. And we say that there isn't a requirement that it be part of that company contract. It just needs to be that that agreement or that understanding between the parties reveals the nullity of the company because it's contrary to the company contract. And of course, if we're wrong on those points, we have all of our backup points as to whether it does need to in fact be binding or not, and that it is in fact an addendum to the company contract. So we say that clearly we have a real prospect of success on ground 1.1. We also take a point on Your Excellency's distinguishing of the Cafe Rider case. We don't need, I stress, to succeed on this for us to succeed on our appeal, but it is, we say, another string to our bow if we're right about Cafe Rider being applicable. And we say ultimately the point is that if I'm right about the side agreement being binding, then there is no point of distinction between Cafe Rider and this case. But we have another point too, which is that we say that Cafe Rider doesn't address the question of binding and non-binding. And it's unclear, we say, that this formed any part of the decision, because in fact the operative part of the judgment, and I think we should hopefully still be in the Cafe Rider case, at the very bottom of page 1315, shows that the agreement of the 14th of August 2013, so that's the side agreement, is one in which the appellee acknowledged that the company's assets, properties, funds, requisites and related materials of any type or nature were owned by the plaintiffs. So that's the agreement where it was waived. One can see that in relation to that agreement at 1314, so we can see it's the same agreement because that's dated the 14th of August 2013, and one can see at 1314, it's about in the middle of the biggest block of text on that page. After the words binding force, semicolon, it says we're not affected by the existence of an unauthenticated private agreement dated 14th of August 2013. So again, we say that the fact that it's referenced as being unauthenticated is something which, if it were a relevant point, suggests rather that it's similar to our case. In fact, our case we say is stronger as a fortiori because our case is signed and witnessed, but this appears not to have been signed and witnessed, and it's referred to only as a private agreement. So the status of the agreement, we say, is something that wasn't really an issue, but to the extent it was an issue, it in fact supports our case, and our case is stronger. Now, again, with the test for permission to appeal in mind, we say that this question of whether Cafe Rider ought to be distinguished or not is a point of law, and again, it's one on which we have a real prospect of success. So that then takes me to ground 1.2, which is what are the consequences, if I'm right, of GMG being a nullity on the TPA agreement. Now, this point was dealt with by Your Excellency at paragraph 25 of the judgment, where you found that there's no suggestion in any law or judgment that a debtor can be released from a debt to a company or any contract set aside or avoided owing to a declaration of invalidity of the company. Now, in fact, we say that the position at the hearing was that there was also no case which suggests that it can be done, but to the opposite, the cases referring to de facto companies were, as we submitted, in the context of parties claiming debts payable by the de facto company. So not de facto companies claiming rights owed to them, but people claiming against de facto companies for rights that the de facto company owe. So, for instance, at Dubai Court of Cassation case 330-2000 at page 873, and this is the one I took Your Excellency to earlier, we can see in this case that it was about checks that had been written by the company that had been bounced. A claim was made, and in this case, the company was found to be null and void, but to exist as a de facto company for the purposes of discharging the debt, so the debt owed by the company. Now, we say that when one reasons from first principles, of course there are no cases where the de facto company is used to bring in a debt rather than to pay a debt. And that's because if a contract that is made for the benefit of a company, which is itself void ab initio as a result of it being declared a nullity, we say that it's declared a nullity because it is, in essence, it's breached a rule of public policy or public order. And we say if it's declared a nullity as a result of breaching a rule of public order, there are good reasons why it should not be able to benefit from it having breached that rule of public order. There must be consequences of the company breaching it. But on the other hand, third parties who've dealt with the company innocently should not be punished by reason of the company's wrongdoing, and that is why the de facto company exists, so that it can be sued, and then ultimately the partners that are behind it, the true partners that are responsible, are then required to pay those amounts. Now, we also have all of the other points about whether the concept of de facto company even arises under the 85 Act, as opposed to the 2015 Act that we ran below. But just addressing directly, if it is in concept, then we say that starting from first principles, what should have been important was the fact that there were no cases suggesting that GLOBEMED could do as they have attempted to do, but reasoning from first principles, that's why, and that's why the cases which there are about the de facto company paying debts. We say that this case is also lent further support by the new case we've referred to in our permission to appeal application of the Dubai Court of Cassation 585 2023, and that is at page 1321. Now, that case does, we say, go some way to establishing that contracts made by a null company are also null and void. In that case, a company contract was concluded, and there was then an unnotarized agreement made which relieved the local partner from profit and loss. Subsequently, the partners arbitrated a dispute on the basis of an arbitration clause in the company contract, and then an application was made to the Dubai court to set aside the award on the grounds that the company contract was void. And the upshot was that the Dubai Court of Cassation agreed and declared the company contract and the arbitration agreement, and accordingly arbitration was void. And one can see that from page 1327, where it says the Commercial Companies Law and the Public Order, which proves the voidness of the second cassation appellee company's contract, which includes the arbitration clause, according to which the arbitral award, the subject matter of this case, was issued. And then it goes on to say the submitted documents reveal that the reason for filing the present case is the voidness of the arbitration clause, since the arbitration tribunal is not competent to consider the case due to the voidness of the memorandum of association containing the arbitration clause. The voidness of the memorandum of association extends to include the arbitration clause, which means that the dispute of the arbitration clause does not fall within the competence of the arbitration. Now, we accept, of course, that this is not exactly the same scenario. It's a different scenario. It's a scenario which concerns the arbitration. But what we do say is it is analogous to our situation. As Your Excellency, of course, knows, an arbitration agreement in a contract is a separate agreement. It's severable from the agreement in which it's contained. And the arbitration award is the product of an agreement reached between the parties. Arbitration is, of course, all about consensual dispute resolution. There has to be a clause which provides authority, jurisdiction to the tribunal to hear it. So we say it is significant that in this case, where the company contract was void, that the arbitration clause was also found to be void, and consequently the award issued on the strength of the arbitration was void. And we say that that is analogous to our situation, where a contract is made by a void company, and we say the result of that is that the agreement itself is void. And because the company is void as a matter of breach of public order, it shouldn't be indulged by being allowed to claim on it. Now, again, we say that this is a point that we have at least reasonable prospects of success on. And so we say that this is a ground on which we ought to be granted permission to appeal. So, Your Excellency, unless there are any questions from you, that concludes all I have to say about nullity.
Please proceed.
I'm grateful. So I think I can speed up now. And the next point is certainty of damages. And we have three parts to the question of certainty. We say that Your Excellency, having found correctly that in order for damages to be recoverable, they must be certain or inevitable, the finding was then incorrectly applied. So that legal test was incorrectly applied in respect of the OIC loss, where we also say it wasn't applied at all, the Bupa portfolio part of the OIC loss, and finally the non-OIC loss. Now, we stress at this stage that we don't seek to challenge Your Excellency's findings of fact as part of this challenge. Rather, we say simply that the findings of fact that Your Excellency did make and having correctly directed yourself as to the law for the requirements of certainty, we say that the error in the judgment is that that correct legal test was not then applied to the facts as you found them. We say that this is an error in the application of the legal test, and we say, therefore, it is a question which is open to challenge on appeal without us having to say that Your Excellency is plainly wrong. In the alternative, if we have to, then we will say that the judgment in that regard was plainly wrong. But we say that primarily it's not required, and that isn't our primary case. So starting first with the OIC loss, we say that it's significant that the judgment doesn't contain any express finding that GLOBEMED's claimed OIC loss was in fact certain or inevitable to occur. So the judgment sets out the requirements of certainty and then goes on to look at the savings and discrete parts such as the Bupa portfolio, but doesn't in fact step back and assess whether the OIC loss claimed by GLOBEMED was certain or inevitable as against the test that Your Excellency set out. Although Declaration 4 appears to assume that the OIC losses have in fact been awarded. And we say that this is something that a Court of Appeal would be able to and should look at, which is simply as to whether the OIC losses, because this was obviously part of our argument below, are something that are certain or inevitable and that should be recoverable. And we say that had Your Excellency directed your mind to the point, we say that it's at least arguable that you would have found that they were not. And that is because we say that the generation of profit as a general concept is not in and of itself certain or inevitable. That's a point we made in our skeleton below. It's said against me that this wasn't run, but it was in fact. One can see paragraph 87 of our skeleton argument for the trial below. We refer there to Dubai Court of Cassation case 371 of 2004, and the fact that the court stated in the context of a claim for loss of profit that such loss was recoverable only where it was certain to occur, and that where the damage, the claimant's claim is for expectation for certain amounts to be reached by the future sales and profits, these were potential damages that are not sufficient to order compensation. So we say our point was that the starting point is that future sales and profits, which is what this would have been, it was at the point of termination. What was being asked is, would there have been future sales and profits, is something that ought to have been analysed. We also say that the evidence before Your Excellency was that GLOBEMED was an inexperienced company which was a new entrant to the market. And again, it's said that that wasn't a point made below, but in fact one can see paragraph 46 of the skeleton if one goes up in the same document, pages 360 to 361. That is the very case we were running. We say this will be explored further with the experts at trial, but as a matter of logic, where GLOBEMED would have been a new entrant to the market and would have been under the majority ownership of OIC, it's easy to see why other insurers would have been reluctant to use GMGHS as their TPA provider. Going on, as a matter of UAE law, for a claim that is already for the loss of projected profits by reference to projected lives and complex projections of costs is already uncertain. And then we go on to make a point about the non-OIC loss. And then finally, we say that the figures on which the OIC loss was calculated were not the lives which GLOBEMED would have managed, but the lives which Oman Insurance in fact managed in the absence of the TPA. So in applying the counterfactual, one is looking not at what GLOBEMED would have done, but one is looking at what OIC did in fact do, and then extrapolating. And we say that that's the sort of thing that ought to have been considered as to whether it is in fact recoverable as a matter of UAE law. So we do say it's significant that Your Excellency doesn't appear to have looked and stepped back and looked at that point. And we say this isn't a matter of island hopping, as my learned friend says. It's not a matter of isolated textual analysis. We're saying that our primary point on OIC loss was that it was by its nature not recoverable. And we say that Your Excellency, having correctly found what the law was, should then have asked that question. Moving on then to Bupa, we say that if Your Excellency is not with me on the general position, we do have other points specifically in relation to Bupa. And we say again, the point is that we're not challenging the legal test that Your Excellency found, but the way the legal test was applied. Now, the basis on which Your Excellency found that the Bupa portfolio would have been transferred rested on efforts that OIC would have made as a result of your finding that if it were not transferred, then OIC would be contractually bound to abandon the portfolio. Now, we have 3 points to this. First, we say that this is evidence of what OIC would have done, not what Bupa would have done. And so in that regard, we say the wrong question was asked. Second, we say that even if OIC's actions were sufficiently relevant, it was wrong to decide that on the basis that OIC was contractually bound to consent to the transfer, then that made matters sufficiently certain, because in fact the provision made for in the terms of the joint venture agreement, the MOU, on which we say the TPA agreement depended, provided that if Bupa's consent wasn't obtained, then the fee structure would be entirely renegotiated. So that rather suggests that the Bupa portfolio would not have been abandoned, but rather that the parties would have come to a different agreement between themselves. So the driving factor behind finding certainty, we say, was itself based on an incorrect premise. And finally, then, we note that Your Excellency had some difficulty in identifying the point in time by which the transfer would occur. And we say that that rather suggests that the whole matter of the transfer was too uncertain. So moving then to the final part of my submissions on certainty, and that is non-OIC loss. Now, at paragraph 93 of the judgment, Your Excellency found it more likely than not that GLOBEMED could have built non-OIC business on the back of its OIC business to a significant extent. But in your view, the evidence before the court did not support a stronger conclusion than that in relation to the whole claim. And we say that finding was quite right, because we say that this is indirect loss, which is loss of a nature which is not recoverable at UAE law. This was a point, of course, that we ran below, and one can see in Al-Sanhuri, again at 1386 of the PTA bundle, paragraph 451, a statement to this effect. So there it says contractual indirect damage, which is not compensable under either contractual or tort liability, is excluded from compensation. Therefore, compensation is solely applicable to direct damage in cases of both contractual and tort liabilities. So we say that that should have been the starting point, that this is indirect damage. We say it's indirect because it doesn't depend on performing the contract that GLOBEMED said OIC terminated and failed to perform, but it is dependent on GLOBEMED obtaining and then the performance of other contracts with other parties. So it is, in essence, twice removed from the breach that is alleged against OIC. In that sense, we say it's indirect, and we say the rule of UAE law is clear. And again, we say this is a straightforward point of law. We say that the fact that Your Excellency then went on to suggest that it was only 25% of this amount which could be recovered rather evidences or shows that the indirect damage is not, as a head of loss, something that is certain to occur and is not something that is ordinarily recoverable. So we say that in that case, we again have a reasonable prospect of success of persuading the Court of Appeal that indirect damage of this nature is not recoverable at all. So that then brings me to the question of the 51% reduction. This is the point, of course, as to whether the MOU, which provided that OIC's subsidiary was to take a 51% shareholding, ought to be taken into account in circumstances where GMG is considered as having conducted business under the contract and therefore having generated profit. So in other words, what we're saying is if one looks at the counterfactual, the counterfactual being what profit would GMG have earned had there been no breach, had the contract been performed, then we say this is an essential ingredient that one needs to take into account. And we note here that Your Excellency found that the conclusion that there was no 51% reduction might be considered to be a windfall, which suggests that it is GMG getting something for nothing, but also that when Your Excellency reached this conclusion, it was said to be not untroubling, and that's at paragraph 124 of your judgment. We say that's an indication that the result is at least open to challenge on appeal. Now, obviously, we don't need to go so far as to say that we're right today about the 51% reduction, but we do say in our appeal that that is in fact the case. And we note that Your Excellency found that it is inconceivable that OIC would have performed the TPA agreement without the share transfer having taken place. And that's at paragraph 124. If it assists, this is at page 41 and 42 of Your Excellency's judgment. I think, by the way, just to clarify, at 122, there might be a not missing in the third to last sentence. I think that should read, but for the same reason, it seems to me to be equally unlikely, which is to say not even remotely likely, that had OIC gone ahead with the TPA agreement, it would have via Synergise not affected the share transfer. Certainly that would then be consistent with what's said at 124, where you say the difficulty here is that it's inconceivable that OIC would have performed the TPA agreement without the share transfer having taken place. So the simple point, Your Excellency, is that this is a factor that needs to be taken into account in the counterfactual. So if the point of the award of damages at UAE law is to consider what profit GlobeMed would have earned had OIC not terminated the agreement, then we say it's plainly right that the profit needs to be calculated on the basis that Your Excellency found would have occurred had the agreement been performed. So, in other words, 51% of the profit would have gone elsewhere because the share transfer would have occurred. This, we say, is no different to theoretical or hypothetical savings that would have been occurred. What GMG is being awarded is its profit. And so one needs to take into account the amounts of money that it would have incurred in generating that profit, but did not. And that's, of course, why one looks at the savings. And we say that this 51% is just squarely in that category. It is money that would have had to be handed over by GMG had it been in the position to generate this profit in the first place. So we say that it isn't right to look at this as a question of whether GlobeMed would have had a right to take a shareholding through an indirect subsidiary. We say it's not relevant that in circumstances where the TPA agreement was not performed, that Synergise did not take the transfer, because as Your Excellency correctly found in the counterfactual, it's something which would have happened if GlobeMed were in a position to generate profit at all. This is a short point, and we say that it is, again, something that we have at least a real prospect of success on. So that then takes me to my very last point, which is really just a repetition of what I said at the start, which is costs, and just to stress that costs is not its own independent ground of appeal, but we do ask that if we're granted permission to appeal on any of the other grounds, that we are also granted permission to appeal costs, just to make clear that the Court of Appeal might give a different costs award. Your Excellency, I'll just check very quickly if there is anything else that those instructing wants me to cover, but are there any questions that Your Excellency has on any of those points?
No, not at this stage. Thank you.
Your Excellency, would you like to hear from me now? Would you like a break?
I think you will go for nearly 1 hour, perhaps.
About that, approximately, yes.
So shall we just have a very short break? I'll come back 12:15 Dubai time.
12:15.
10 minutes. Yeah.
Thank you.
I will not leave here. I just want to. I will turn off my camera. Yeah.
Very good.
Yes.
Your Excellency. So, Your Excellency, I'm going to approach it in the same order as my learned friend. You've heard that there are 5 grounds of appeal, but we don't really need to concern ourselves with the costs issue because that just depends on the outcome of the others. So I won't say anything more about that. The first ground of appeal is this nullity point. And then you've got grounds 2 and 3, which we say are squarely on the facts. just an attempt to overturn your decision on the facts. And you should have no real concerns about rejecting those. And then we've got ground 4, which is a pretty extraordinary argument, frankly, about the 51% deduction, which just ignores company personality altogether. But there we are. So I'll take them in that order. I would, however, note at the outset, my own friend's submissions today ranged rather widely. So we've got new points that are taken for the first time. It appeared at one point, and it's unclear whether this is the case, that my own friend is advancing a new case in relation to nullity, that the side agreement itself is a sham. But I'll come to that. I don't know whether or not that is the case that's being advanced. If it is, it's not open to my learned friend. At least for today, we say my learned friend should be confined to his actual grounds of appeal, and not be permitted just to come up with things on the hoof. You know the test is real prospect of success, and I'll come to the test when it comes to issues of facts, but I'm going to start with ground 1. And there's quite a lot to say about all of this, but we have to remember that this part of the case falls into 2 parts. The first part being, is there a nullity problem? Is there a breach of these provisions of the company's law? And then the second part being, well, what if that is right? What are the consequences on that? And I'll look at it in 2 parts, but we always have to bear that in mind. My learned friend has to have a real prospect on both aspects of that. And we say he doesn't get close on either, but particularly when it comes to the consequences. It just doesn't work. His case now is that there's a de facto company, but only for the purpose of paying debts. Just pausing there. Paying debts with what? How can the company pay debts if it doesn't have any assets, if it doesn't have any rights? It can't go to its bank and say, you, the bank, you owe me money. You owe me my money because I've got the bank. The bank says, no, you're a nullity. I'm not going to give you your money. How's the company paying its debts? So once you get to the point that there is a de facto company of any sort, logically, the whole case falls apart. But I'll come back to that briefly at the end. Just stepping back, I mean, it is a very strange case if you think about it. So the proposition is there's nothing wrong with the company contract. You set up a contract, but then you enter into an agreement of this sort, and suddenly the company just disappears, vanishes. Not only does the company vanish, all its contracts vanish. So even if you could somehow construct a situation where the company is still alive just to pay its debts, again, the fact that it vanishes and can't pursue any of its rights is going to affect all kinds of third parties who have no responsibility for any of this. Counterparties to contracts, employees, where are they going to get their pay from? Because the company can't actually do anything to get in its assets. It's a very, very strange proposition that's the effect of UA law, and you would need to be really shown something that establishes that. And my own friend accepts there's no case that he can point to which demonstrates that the company in that position can't actually pursue its debts. Now, in relation to the standard on this, though, I mean, Your Excellency obviously has looked at this now in a great amount of detail, and what's being said is, well, we should just do it all again in front of the Court of Appeal. My learned friend said yesterday in relation to UA law, you were, Your Excellency, as the perfect tribunal. And he said that in that context. No doubt he won't accept it in this context. But I think it's right that on this sort of issue, the Court of Appeal will have a degree of deference because you have delved into all of this. You have looked into it in some detail. And what they will need to see to overturn Your Excellency's decision is something that actually shows that your analysis is wrong, that is engaged with your analysis properly and has said, well, this is where you've gone wrong. It's not enough just to say, well, let's start again from scratch and run the whole point. And my learned friend says, well, this is all on the documents, and so it's the kind of thing that courts of appeal look at. That's inconsistent with his points about deference to contractual construction. But the other point that's being made is this is an allegation of sham. So in other words, what is being said is that the parties to the contract, the company contract, as a matter of fact, did not intend it to mean what it says. So that's a serious allegation. It's essentially an allegation of fraud. They've put together a fraudulent document which they've registered with the company's registry, and they've presented to the world as being truthful and truthfully containing their agreement. But it's a sham. Now, my learned friend tries to do this on the papers in one way, which is to say the effect of the side agreement is sort of to amend the company contract, but they just didn't tell anyone about the amendment. That's all about what the side agreement means. But then he also has this point, well, you can prove it through any means of proof that it's a sham, and look at this document and look at that document. That is going beyond the question of the effect of the side agreement on the company contract. That is pure fact. That is purely saying that individual who signed that document can't genuinely have meant that to mean what it says, because look at this document and look at that document. That's an appeal against factual findings that the parties intended the contractual document to be what it said. And that is not available to my learned friend today. He hasn't set out a case on that in the skeleton argument. He hasn't got a ground of appeal on that basis. We say, at least the way it's being put, wasn't run at trial, and in any event it would be pure factual appeal on an issue of an allegation of very serious fraud, essentially. This court, Your Excellency, you've heard from the individuals, or at least some of them, who were involved in signing that agreement. Ms. Atala, for example, there was cross-examination on the issue. You've reached the conclusion that the company agreement meant what it said, and the Court of Appeal is not going to impose its own findings that, as a matter of fact, that document wasn't intended to mean what it said. So the way it is put in the skeleton argument, if we look at, I don't know if you've got my learned friend's skeleton argument, paragraph, it's page 9 of his skeleton argument. If you've got it loose, yeah, I can refer to the page of the document itself. So paragraph 40, this is an appeal concerning the interpretation of a contractual provision. Matters of interpretation are questions of law and are therefore apt for reconsideration on appeal. So he's not saying you look outside the four corners of the contracts. What he's saying in this document is, look at the side agreement, look at its effect on the contractual arrangements for the company, and that means that the whole company has blown up and winked, as he says, out of existence. That's what his case is. Now, my learned friend said yesterday there may be a degree of deference to even contractual construction. I'll come on to that. But what this does is it limits my learned friend's case to the terms of the two agreements, the company contract and the side agreement. So just going then through his skeleton argument and trying to pick up some of the points that my learned friend made along the way. Paragraph 41, sets out what is the sort of starting point of my learned friend's argument. I'll take it in a slightly different order to the way that he puts it, but effectively 41.1.2, he's pointing to the terms of the preamble to the side agreement. And you'll recall it said sort of true agreement, and this is the true agreement and all the rest of it. Now, Your Excellency's point in the judgment was that in order to actually understand what the side agreement does, you have to look at its terms. The preamble is just a broad description of it, but you actually have to look at the terms of the agreement. That's your judgment at paragraph 11. Now, we say that's obviously correct. The terms of the agreement are what defines what its effect is. And it's unclear to me whether or not my learned friend is saying something different. It's not clear to me, sitting here today, whether what he wants to say is actually that the side agreement doesn't mean what it says. It means something else. And at times he says something different. And ultimately, what we have to therefore look at are the terms. What do the terms say? And the other point is, if we go to the side agreement itself, I've been working from a slightly different version. I don't think there are any particular points of interpretation that we would specifically rely on. Safe to say that one can't. I think the point that Your Excellency was making when looking at this side agreement was that you can't get too stuck on the precise language that's being used, because this is always going to be in translation. But the side agreement's at 285 of the bundle. And then at bottom of 285, you'll see the ending of the preamble. So my learned friend says, effectively, at least in the skeleton, it relies on some of the things that are said in this preamble. You'll see that the point that Your Excellency alighted on in this was in the last two lines of that preamble, so where it says, the parties have agreed that they shall exercise their rights and obligations related to the company in accordance with the terms of this present agreement. So Your Excellency makes two broad points. One is, when you go through this agreement, you will see actually that if it was binding, its effect would be that Mr. Helu still had the shares, still had the profits. He's just agreeing what he's going to do with those. And the second point is, but it's not binding anyway. So in relation to the first point, we go over the page, you can look, and this just to remind you of Your Excellency's points on page 286. So for example, Article 5, if the first party desires to assign all or part of its shares, that's a reference to Mr. Helu, because he's the first party. So it's a don't assign agreement. So if that's binding, the obvious logical consequence of that is that he must still have the shares. My learned friend says, well, this is all just language, and he tries to explain away these issues by looking at language, the particular words that are used. But if you look at the substance of that clause, it just doesn't make any sense if Mr. Helu is not in fact the owner of the shares. And it's the same for Article 6, and the other one that Your Excellency relied on was Article 9, cases of mandatory assignment of shares. And so that's on page 287, which says that in these events you have to assign the shares. So when my learned friend said, well, his shares is just a shorthand for meaning the shares which he has already assigned to you, but that can't be right on the meaning of this term, because the structure of these clauses requires him to actually have their shares. So there's no assignment at that stage, and that we say is clearly a correct finding, and nothing you've heard today can help you, would persuade you that that's wrong. So when it comes to the shareholding requirement of the company's law, that can't have been breached by this sort of arrangement, even if it was enforceable. And the other point is in relation to the agreement to waive profits, which my learned friend was very dismissive about. That's Article 10, which says the first party undertakes to assign its profits in the company. Now, the point here, which my learned friend professed not to understand, is that if I'm agreeing to waive, I haven't yet waived. And if the law is banning on waiver, then this agreement by itself is not contravening that obligation. My learned friend was extremely dismissive of this. And he said, well, if you ask the question, has Mr. Helu agreed to waive the profits? Then the answer is yes, but that's not the test. The test is whether he has waived the profits. My friend says, well, he doesn't understand this point. This is my point. It's not my point. This is Your Excellency's point. I mean, he's laughing in the background now, but you made the point in the judgment. So that's page 9 of the bundle, paragraph 13. Your Excellency yourself says, while the side agreement provision was made for Mr. Helu to waive his profits, that does not, in my judgment, itself amount to a waiver of profits. Not my point. So for my learned friend to turn up and say, that's nonsensical, I don't understand it, so I don't have to deal with it, is not good enough. You can't turn up to a court and say, you, judge, have reached a conclusion that's nonsense. Give me permission to appeal. It's astonishing, frankly. But there we are. That's all the position if the agreement is binding and enforceable. But what if it's not enforceable at all? My learned friend says, well, it doesn't need to be binding because the side agreement demonstrated an intention not to act in accordance with the ownership rules and the profit rules. That's what he's saying. So he's saying not only does there need to be breach of the obligation to actually own, breach of the obligation not to waive, he says it's enough to demonstrate an intention not to, quote, act in accordance with those rules. But it's the breach of the rules themselves which give rise to the issue, not an intention to breach the rules. And what is the intention to breach the rules? The allegation is not explained. So just again, stepping back a little bit, the argument run at trial was that the terms of the Hello Agreement amended or replaced the company agreement, or alternatively, they showed that the company agreement was a sham. So again, to test that, you have to look at the terms of the Hello Agreement. Does it do what they say it does? And the answer, if it's not binding, is clearly no, because unless that document itself, unless the side agreement's a sham, the intention of the side agreement is precisely what the side agreement says its intention and its terms are. And if the intention is it's not binding, then the intention cannot be to amend the company agreement, cannot be to replace the company agreement, cannot be to waive profit. So it all comes down to the construction of the side agreement. And to go beyond that, you'd have to say the side agreement doesn't do what it says and is effectively a sham. And that is not a case which is open to my learned friend. And as far as we can understand, the case, at least the case that's in writing, is that it's the effect of the side agreement that's the problem. And that's what breaches the rules. And on that basis, you have to consider its effect. And just then picking up the argument that in fact it is binding. I mean, all of that is very difficult, because if we go to page 290 and we look at clause 24.
The page again?
290, please.
Yeah.
You'll recall this, and it's also at 297, and I think that was the page that my learner friend took you to. I don't think this bit is materially different, but it's the last line. It says, well, it's the second part of this paragraph. It's hereby understood and agreed that the first party was appointed as a citizen partner, as is required for the incorporation of the company, and not as an actual partner in the company. Based on the same, this agreement shall not be considered, interpreted, or construed in any case whatsoever as an actual contract between the parties. I mean, how do you get around that unless you say that isn't what it says it is? You can't interpret that out of this agreement. You have to say that is a sham. And my learned friend came very close to that. In his skeleton, he's got nothing at all to say about this provision. What he did in orally was to amplify on various points that were made in the skeleton argument as to why the other clauses of the agreement show that it must be binding. And he gave, I think, 10 examples. You won't find that many in his skeleton argument. But largely, the points he's making are to point to the other provisions and say, well, those refer to agreements. Those refer to undertakings. Well, parties can enter into non-binding agreements. It's perfectly ordinary, and there's nothing to stop them doing that. So reference to agreements that doesn't contradict the conclusion that those agreements are not binding. And there are other linguistic points that were made about the word current, for example, that somehow that suggested that it was binding, but you can have a current understanding which is non-binding. So that doesn't inform the debate. There's reference to clause 22 and clause 23. None of this has been argued in writing, and we would have points to make against it. But for example, clause 22 talks about if any article or clause becomes null because it violates the law. So it's presupposing that there has been a clause which is binding, and then it doesn't become binding because there's been a nullification of the law. But the bottom line on these sorts of points is that these are boilerplate clauses, and the answer to all of it is that none of them really inform the question about whether or not this is intended to be a contract. Only Article 24 itself says anything about that, and that on it is clear. So we have this new argument. Nothing is said in the skeleton about Article 24. So we have this new argument that clause, and it's difficult to follow it because my learned friend's moving quite fast. But essentially what he, as I understood him to be saying, was clause 24 demonstrates that this was all a big sham. So in other words, he's saying, well, it's sort of effectively, this is just a window dressing. It's saying, well, we know that we can't do this, but we're going to do it anyway, but we're going to say that we're not really doing it. Seems to be the thrust of his submission. That is an argument that the side agreement is a sham, that this provision is a sham provision. That needs to be put to the witnesses. That needs to be advanced at trial. And it's not open to a party to come and make a new particular fraud, effectively, at a permission to appeal stage in this way. And you were taken to various other points, like the letter in the trial bundle. Again, that's not part of this appeal. It's not referred to anywhere in the skeleton argument. And again, unless the case is that somehow that document shows that the side agreement is not true, well, then it doesn't take my learned friend any further. What he said is that those documents help you understand what the side agreement means, but none of that is going to take you away from these very clear words of Article 24. And if that's right, then we say that is the end of it, if it's not binding. So it just, Article 24 is a bullet in the head of this argument, if I can put it like that. Now, we have referred to as to whether or not it needs to be binding. I mean, it plainly does need to be binding, we say. So we note a recent Union Supreme Court decision. You were shown some of it, just to make sure that you were showing the bit that we rely on. Maybe that you've already seen this. It's page 1301. And this sets out, we say, what's required. It's in the middle of page 1301. This is a relatively recent Union Supreme Court decision. And it says it's well settled by this court that fictitiousness is proven when the parties to the contract agree to hide their transactions and real legal positions in an apparent contract that has been executed to be a front for their dealings with the public in the presence of a letter or agreement that is in force between them. Upon establishment of fictitiousness, the undisclosed agreement shall prevail over the apparent one. So what you require is that a party is hiding the real legal position. Do you see that second line? So there needs to be a document which is in force, which discloses the real legal position. And without that, you don't get to sham. And it said, well, you can have a non-binding understanding as to how the parties will deal with shares, will deal with profits, and that destroys the entirety of the company. And now you're into really extreme case. I mean, consider a security arrangement where I pledge my shares. What about a situation where I pledge my profits to a lender? I mean, but my learned friends, it goes even further and says, if I say to a family member, don't worry, I'll give you all the profits from my companies, you know, then that is, if in a non-binding way, then that destroys the company. It's a very, very extreme case. In relation to the profits, there is another point, which is that the agreement has to be in the company contract. My learned friend doesn't dispute that the side agreement is not the company contract. He just says, well, it doesn't have to be in the company contract. And we can see that in his case of 585 of 2023. The starting point on this is just the law. And if we go to page 727, we see what's required. Sorry, 729. I'll show you both laws, the 1984 law and the 2015 law. 729 is Article 18, if the company contract excludes a partner from profit or exempts him from loss. So the law says it's in the company contract. The other provision in the 2015 law, you'll find at page 760, it's Article 29.3. If it is agreed in the company memorandum to deprive any of the partners from profit. So that is the requirement in the law. And obviously the law, if the consequences of breaching this rule are so severe, as my learned friend says, that the company is destroyed, then clearly that's going to be strictly interpreted. Now, what is said in the writing is that you can see from our case 585 of 2023 that it doesn't have to be in the company contract. But at least in writing, what my learned friend failed to draw your attention to is the fact that the side agreement in that case was an amendment to the company contract. And you can see that on page 1322. So we're looking at this case. Now, my learned friend says this case, which is, as I say, 585 of 2023, changes everything. It doesn't. And it's relied on in particular in relation to 2 points. And this is the first point. And the first point that was made in writing in relation to this is that the agreement to exclude profits doesn't need to be in the company document. But you can see that this says nothing of the sort, because on page 1322, 4 lines down, the complaint, the centre of the case, is that they concluded an addendum to the memorandum of association, which was not attested, whereby they agreed that the defendant may not have any capital in the second defendant company. So that was a case where the company contract, as amended, contained the provisions which were infringing the rules. So the case doesn't assist him, the law doesn't assist him. And my learned friend says, well, the side agreement amends the company contracts. That requires him to show that it's binding, because if it's not binding, then it all falls away. So there you go. But the other point is the one that Your Excellency made, which my learned friend doesn't comment on, which is that the side agreement actually distinguishes itself from the company contract expressly. That's on page 286. It defines the agreement as the agreement, it's 286, the agreement of the present partners, which differs from the partnership agreement. So the result on this first element of the nullity case is that the side agreement wasn't binding, and that's the end of it. The side agreement doesn't purport to infringe the rules, even if it was binding, either on the shares, because they were still held by Mr. Helou, or on the profit arrangements, because there was no actual waiver, and even if there was a waiver, it wasn't in the company agreement. And there's no arguable response to any of these points. We have a flurry of new points today, which doesn't fill one with confidence, but none of them can overcome these very simple points. And those simple points also explain why the Cafe Rider case is not on point, because in that there wasn't a binding agreement, and in that the true position, which was affected by the binding agreement, was that the local shareholder had actually given up his shares and had actually given up his rights, and you mentioned that in your judgment. So that is why there's no realistic case that anyone's going to overturn Your Excellency's judgment, and that's before we even get to the consequences. Now, put all that aside, imagine I'm wrong about that. You've got these breaches of the company's legislation. What's the effect of that? Is the answer that the company disappears from existence and it can't enforce any of its rights, can't enforce any of its contracts? We say that's obviously not the answer. Very clearly, that's not the answer. There would be a de facto company that would continue in existence until it was liquidated. Now, we can show you that very clearly. We can show you that in the authorities. But to some extent, it appears to be conceded. It was conceded at trial. We point that out in our skeleton. My learned friend says, well, there was a limited concession. So I'll come on to that in a moment. But just think about this for a moment. What is a liquidation? So if you accept that a company which is found to have infringed these articles is to be liquidated, what happens in a liquidation? The process of liquidation involves getting in the company's assets, getting in the company's rights, and then settling its debts. So we recite some of this in our skeleton argument and the support for this, about which you've heard nothing. So if you go to our skeleton, this is our skeleton argument, paragraph 56. And we refer, for example, to the definition of liquidation at 56.4, which comes from case 70 of 2007. It's a sale of its assets, collection of its rights, payment of its debts. So if it is right that companies which infringe these articles are to be liquidated, and that's what all the cases say that we can find, then that includes collection of rights. And that therefore logically means that it has rights, it can enforce those rights. And that again is simply the end of my learned friend's argument on this. Now, we mentioned this, you can see at paragraph 57 of our skeleton what was said in opening by my learned friend's clients. We would accept that a de facto company arises where a company is a nullity that has conducted business. But we say that it arises for limited purposes, i.e. to satisfy debts owed by the company, not to pursue debts to the company, i.e. to allow third parties to pursue claims against the company. It arises as between departments in liquidation and so on. Now, that seems to be what's being advanced today. So it seems to be said, all right, we accept there's a de facto company, but it only exists to pay its debts. And as I've mentioned at the outset, that is, with respect, a totally illogical, incoherent position. Because if a company can pay its debts but can't get its rights, then it can have nothing with which to pay its debts. My entitlement to money, if a company keeps money in its bank, my relationship with my bank is a contractual relationship and one of debt. They haven't got my stuff. They owe me money. How can I get that money to pay my debtors if I can't enforce my contracts? So it doesn't make any sense. And there's absolutely nothing in the cases to support that distinction. Nothing at all. Once you get to de facto company, that is the end of it. Now, my learned friend in his written case relies on this case of 585 of 2023, this new case that was introduced in relation to this appeal. And in his written case, he said, well, this shows that the effect of a company breaching these rules being a nullity is that all of its contracts are void. Now, he didn't advance that position already today because it's just not sustainable on the facts of that case. It just isn't what the case said. I'll just show you that. It's page 1326.
1326.
So the case starts slightly earlier, but I've shown you the beginning of it. So if we go to page 1326, the reason, so his point was that there was an arbitration agreement which became void as a result of the nullity. But you have to understand why. So it's about the middle of the page. It's about 12 lines down or so. It says, it is also established. I don't know if you've got that. It's also established under the rulings rendered by this court. If the dispute presented to the court relates to the nullity of the agreement contracts concluded between both parties and whose subject does not relate to the agreement on arbitration clause included in the contract to be nullified, the nullity of the contract containing the arbitration clause shall extend to include all terms and obligations outlined therein, including the arbitration clause. So for whatever reason, the court in this case has assumed that nullity of the company contract carries with it nullity of all of the terms of the contract, including the arbitration agreement. That's the basis for the decision. It's not saying the company is void and therefore all of its contracts fall away. It doesn't say anything like that. And note in that case, by the way, the appeal by the company, sorry, the case by the company could be brought. The company had sufficient legal personality to actually bring a case. It's one of my learned friends' points today. I can't bring my appeal, I can't bring my case because my company doesn't exist. I'm not here acting for a company. I'm just here as an individual who thinks he's acting for a company. The court hasn't received court fees from the company. It's just received court fees from the individual who happened to be in control of the bank account. It's all this sort of stuff. But none of that stopped the Dubai courts from considering this case that was being brought by an entity. So none of those sort of technical points arise. And we also refer to two other cases. I'm only going to show you one of them because we say it answers the point. It introduces a new argument which we would put forward to the Court of Appeal, but I'm not advancing it today, which is that the law has changed. And so now there's no problem, for example, with foreign ownership of shares. So the rule wouldn't be infringed now. I'm not running that point today, but there is a case on that which helps us understand what happens in the intervening period between liquidation and breach of these rules. And it's cassation case 84 of 2023, and I'll just show you that's 1336, so just a little further in the bundle.
Okay, 1336.
Yeah. This is case 84 of 2023, and it's the top right paragraph. So what happens in this case is that the court finds that there's been infringement of these rules, but by the time it gets to court, the law has changed. So what happens is the court says, this court underscores that this conclusion does not undermine the fact that the formal agreement was inherently null and void prior to the issuance of the decree law, which contravened the requirement of the actual partnership stake of 51% by the UAE national at the time. It is in line with the third paragraph of Article 14 of the Commercial Companies Law, which stipulates that the nullity's effect only arises when the nullity decision becomes final. No such judgment was rendered during the validity of Article 10 of the now repealed law. Consequently, the precautionary measure sought in the lawsuit remains unavailing. The court thus rejects the appeal and upholds the appealed judgment. So what that tells us is this is the cassation court, I think it's the cassation court, saying, well, unless and until the company is declared invalid, it can't be wound up. Until that happens, it continues in existence. And so if you don't get to court until after the law has changed, there's nothing to be done. It doesn't make any difference. Now, so this supports 2 points, one of which is not for today, which is that the right law to apply is the law that's applying at the time of the hearing. But we put that to one side. What it tells us is that between the time of the hearing and the time of the infringement, the company remains in existence. So my learned friend says there's no cases which say what happens, but there are cases which say what happens, that the company survives in its original form. So nothing that you've heard, nothing that is in the writing can get over that point either. Even if I'm wrong about all of those points on sham, even if it is a sham, it doesn't take you anywhere. That's my point on, those are my points on ground 1. That's nullity. I'm also going to deal with grounds 2 and 3 together, and I'm also going to do this relatively speedily, I hope. So these 2 grounds are on it. Well, they're dressed up as something slightly different, but they're quite clearly appeals against findings of fact. Your Excellency has found that, as a matter of fact, certain losses were suffered. And my learned friend is trying to overturn that. You found certain losses are suffered by applying a certainty test, but that's just the burden, the standard that we had to meet to establish that those losses had been suffered. My learned friend says, though, this isn't about that. This is about the application of the law to the facts. Now, first, that's obviously wrong. This is about factual findings. But secondly, even if it was the application of the law to the facts, then the court adopts precisely the same approach as it adopts to facts. And the result is you have to show, he has to show that there's a real prospect that the Court of Appeal would find that you made findings which no reasonable judge could find. Now, that, with respect, would be an extremely unusual thing for a first instance judge to do. It's one thing to say, look, there's room for doubt about this, but these are my conclusions. It's another thing to say that conclusion that I reached is completely outside, or potentially completely outside, the bounds of what is reasonable. So the Court of Appeal in the GLOBEMED case has looked at this again and collected the authorities on that. Can I just remind you, I'm sure you recall them all, but I'll just remind you of some of the points that we would highlight in relation to this. And as my learned friend said yesterday, we have to, I'm afraid, zoom in on these particular cases because for whatever reason, the font is very small. But the passages I just wanted to remind you of were firstly paragraph 114, which refers to the McGrady Supreme Court case. The court emphasised that an appellate court would only interfere with the findings of a judge at first instance if it's satisfied that any advantage enjoyed by the trial judge by reason of having seen and heard the witnesses could not be sufficient to explain or justify the trial judge's conclusion, and then only if the judge's conclusion was plainly wrong, and then refers to, if we just go to the last sentence, what matters is whether the decision under appeal is one that no reasonable judge could have reached. 116, in determining whether no reasonable judge could have reached the conclusion under consideration, an appellate court is bound, unless there is compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into consideration, notwithstanding that it may appear that the judgment may not present a balanced account of the evidence. While the trial judge must consider all of the evidence, it need not be discussed in the judgment, as the weight to be given to any aspect of the evidence is preeminently a matter for the judge. An appellate court may only set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration if the judge's conclusion was rationally unsupportable. So this is the height of the case here. 117, the judge should give their reasons in sufficient detail to show the parties, and if need be the Court of Appeal, the principles on which they've acted and the reasons why that have led them to their decision. But there's no duty on a judge to deal with every argument presented by counsel in support of their case. The judge's function is to reach conclusions and give reasons to support their view, not to spell out every matter as if it was summing up to a jury. It is sufficient if what the judge says shows the basis on which they've acted. I'm going to skip the next two paragraphs. 120 may be with the luxury of hindsight and the more limited and narrow focus of the appellate court, that it might feel better able to express certain findings. But as Lord Hoffman in the English Supreme Court said in L.L.C, the exigencies of daily courtroom life are such that reasons for judgment will always be capable of having been better expressed. An appellate court should resist the temptation to subvert the principle. They should not substitute their own discretion for that of the judge by narrow textual analysis, which enables them to claim that he misdirected himself. And then there's Fage UK, which summarises the key points, and they focus on various things. The trial's not addressed rehearsal and so forth, but it's at paragraph 4, one which is often pointed out, which is that in making their decision, the trial judge will have regard to the whole of the sea of the evidence presented to them, whereas an appellate court will only be island hopping. What that's talking about, and what we say, my own friends, doing today, is it's picking out items of evidence and saying, well, look at this evidence in isolation. This must point you in this particular direction. And that generally is not going to be permissible unless you can show that the sea of evidence was such that that conclusion was outside of the reasonable range. Now, the other point to be made is that all of this also applies to inferences to be drawn. I don't need to take you to that as page 964 of the bundle, the authority there. But it applies to inferences to be drawn. It applies to the application of legal principles to the facts. So, for example, if the question was, has a party acted negligently, then that would be an application of the law to the facts, and that would be also treated with similar deference. Now, my learned friend accepts in his skeleton argument, paragraph 49, and also orally today, that Your Excellency applied the correct test. There is some suggestion in the skeleton argument that you didn't ask yourself the right question, though. That's paragraph 49 again. It said, 5 lines down, had the judge stepped back and asked himself the right question, is GMG's claim for each head of loss in respect of loss which was certain or inevitable, the judge would have answered no. That appears to contradict my learned friend's suggestion that you applied the right principles, because the principles were, it has to be certain. If that is the submission, that you didn't do that, it's obviously wrong. It's clear from your judgment that you're asking the question in relation to all of the losses, is it certain? and then we have to go on and look at what is actually being presented today as saying that you got this all wrong. Now, not all of these were pressed today, but I'm going to give you very briefly my response to them as we go. The first is said that the judgment doesn't contain any express finding that the claimant claimed that the claimant's OIC loss was certain or inevitable. With respect, that is the narrow textual analysis that the Court of Appeal, the Supreme Court in Poglavska said you shouldn't be embarking upon as an appellate court. It's on any fair view of the judgment. Your judgment was aimed at identifying what was certain and what was not certain. That is not a realistic submission. The second reason is that paragraph 50.2, even if it might be said that such a finding was impliedly made, the judge in any event set out no reasons or evidence or explanation for why the claimant's alleged loss was certain or inevitable to occur. That is, with respect, also unreal. You had two disputed calculations before you, and so where there were disputes between the parties, you considered them, you decided them on the basis of what was certain. You didn't have to spell that out. You don't need to give all your reasons in copious detail. But this appears to be allied to the third point, which is that it said generation of profits is always uncertain. So the effect of my learned friend's submission is that you cannot recover lost profits under UA law as a matter of UA law, because A, it requires certainty, and B, generation of profits is always uncertain. So the net conclusion, the logical conclusion of his submission is you can't recover it. That is wrong as a matter of law. Why? Because Article 292 permits recovery of lost profit. I showed you this yesterday. I don't need to take you back to it. The article itself, I think, is at page 733 of the bundle if you want to look at it later. But we have also referred to some authority in our skeleton argument, paragraph 90, for example, and we showed you it yesterday, which is Cassation Case 1108. The law permits whatever profit the harmed party expected to obtain, as long as there are valid reasons for his expectation. We talked about lost earnings and so forth, and you see that from the Ministry of Justice guidance, which you'll find in the bundle at page 1440. So it's quite clear lost profits are certain. My learned friend's attempt to sort of define them out of existence from UA law cannot be right, because they're being awarded, they're provided for in UA law. In this case, you decided that some of the lost profit that we were claiming was certainly lost. That was a decision on the facts, and I'm simply asserting that lost profits can never be certain. It is never going to meet the threshold for an appeal on that sort of thing. Fourth and fifth points then, these are pure island hopping points. So these are assertions where my learned friend is picking up either items of evidence or items of facts and saying, well, these change everything. But Your Excellency had all this, and it's part of the sea of evidence and sea of facts which from which you derived your conclusions. So the fourth point so the first of the two on this footing is that the claimant had no track record, it is said. So no evidence is produced for that. It's a new company, obviously, but the company is part of, and is going to be part of, on the one hand, the GLOBEMED group, and on the other hand, the OIC corporate structure. The people who are arranging, managing the TPA services and the delivery of the services under this agreement are from the GLOBEMED group, which has huge experience in new markets and old, all across the Gulf. That was the whole point of the contract. So the idea that this is some killer point which would disrupt any kind of award of damages is not going to get my learned friend anywhere. And then the point 5, it's asserted that, well, you base the calculation on the OIC lives, And so the assumption is that the OIC lives would be transferred. And I mean, there's no analysis in the skeleton about any of that. And for example, no case is advanced as to how many lives they say would have been. Maybe they say it's not certain any single life would have been transferred from OIC to GLOBEMED pursuant to this contract. And that just illustrates how extreme the case is. As you will recall, OIC was contractually obliged to transfer its portfolio. There was a discrete issue, if you recall, about the 50,000 lives point, and there were circumstances in which the 50,000 lives might be triggered, and the exception to the transfer of the whole. And your Excellency addressed that in the judgment at 87 to 92 and made comments about what would have happened, all in the context of applying the certainty test. And my friend just doesn't even mention those issues. So these are just 2 points that my friend would like to make, plucked from the air, but not set in the sea of evidence. So that's what we say, that is just an attempt to pick out, cherry pick bits of evidence and say, well, OIC losses, it's all generally a bit uncertain. All of that, my friend said that point was made, and you disagreed with it. In relation to ground 3 then, ground 3 is about Bupa. Would Bupa have agreed to transfer? And that is 3 points, again, raised in relation to this. They're on page 13 of my learned friend's skeleton. Actually, they come at page 14 in paragraph 54. There are 3 points there. The first is that, and this was sort of said again today, the evidence relied on is not evidence of Bupa's intentions. That's the way it's put. So the evidence on which the judge based his findings that the Bupa portfolio would have been transferred is not evidence in relation to what Bupa would have done, but is solely in relation to what OIC would have done. That, I'm afraid, is just not correct. It's absolutely not the way that you decided this. And I just need to remind you of how you approached it in your judgment. We need to go to page 28 of the bundle, paragraph 76 of the judgment. And you make a series of points from here about Bupa's motivations, firstly, and secondly, about OIC's motivations. So at 76, you make the point that Bupa was committing resources, and you say both parties were interested. If we go over the page to the top of page 29, you make the point that by reference to contemporaneous email, Bupa was clearly still interested and still committing resources. And you make the obvious conclusion, you draw the obvious inference that Bupa had continuing interest in transferring. So this is evidence of Bupa's motivation. Paragraph 79, you mention that there is copious evidence, and you don't need to go through it all, but to the effect that Bupa was willing to consent to terms. Paragraph 80, you refer to the contemporaneous reports that Bupa would transfer. Overall feedback has been positive, which is an indication that Bupa would transfer. Progress was being made. 81 to 82, you make the point that Bupa's requests were not unreasonable. And that's important because part of the case seems to be, well, because it took such a long time, you can read into that Bupa wasn't really intending to proceed. But if it's not making unreasonable requests, if it's making reasonable requests, then actually that's indicative of quite the opposite, which is just that it wants some issues solved. And then paragraph 83, you say the defendant was highly motivated, and therefore you can infer from that that the problems would inevitably have been resolved. So you've got a set of findings that Bupa was clearly committed. Bupa wanted this to happen. There were problems that were arising, but they weren't making unreasonable requests, and OIC was very motivated and was solving the requests. You put all that together and you can come to a conclusion. It was certainly open to you to come to the conclusion that that it was certain that these would transfer eventually. The second ground, then, we go back to the skeleton, page 14, para 54.2. relies on the MOU and says, well, if the BUPA transfer didn't come across, then the MOU says the contract would have been entirely renegotiated, or sorry, not the fee structure in the TPA would have been entirely renegotiated. First, neither of the parties to the TPA was party to the MOU, so there's no obligation on the claimant to renegotiate anything. And anyway, even if there was a renegotiation, it's not going to be on terms which are less beneficial to the claimant than the terms that were already in existence. But the issue, which is being considered in your judgment at this point, the issue that's under attack is whether it's certain that BUPA would have transferred. And so quite what this has to do with that issue is very unclear. It's wholly tangential. What would have happened if BUPA did not transfer? The issue is about whether or not it would have transferred. And you were entitled to find that the defendant was highly motivated, regardless of what might have occurred if it hadn't eventuated. And then the third point, this is again an attempt to parse the judgment as if it's some sort of statute. So Your Excellency said that there was no evidence about when the transfer would take place. That's on page 31, paragraph 85 of your judgment. And I think what you are saying there, well, my learned friend latches onto that to say, well, the whole transfer was not certain. That, firstly, is a non sequitur. You can be clear that the transfer would have happened, but not be clear exactly when it will happen. And so what you do is you find a date by which you say it would have happened. So if we look at the judgment, paragraph 85, you say, I'm not sure what impact, if any, the date of transfer would have, but just in case it would have an impact, I will attempt to identify a point in time at which it can be said that the transfer certainly would have happened. So there's nothing inconsistent with the way you put that and your conclusion that it was certain that it would have happened. So we say there is nothing in these grounds that would cause you to say, cause you to agree that there is a real prospect that the Court of Appeal would find that your conclusion on this was outside the reasonable range, that no reasonable judge could have reached that conclusion, that it is, as is required, rationally unsupportable. That's the way the Court of Appeal put it in the Tabarak case. In relation to the non-OIC losses then, we've got effectively 2 points which we find at paragraph 58 of the skeleton argument. The first argument is that you made a loss of a chance assessment. And if you made a loss of a chance assessment, that means that loss wasn't certain. The problem with that is that's not what you said at all. What you said was some of the loss was certain, some of it was not, and you assessed the part that was certain. You can see that in paragraph 99 of your judgment, page 36 of the bundle, and it's the final sentence of page 30 of paragraph 99. You say, I accept that the non-OIC losses were all more likely than not, and importantly, that some of those losses were inevitable. It's not a loss of a chance. And then the second point that's raised against us is that it said indirect loss is not recoverable. We don't accept that this is indirect loss. We say this is direct damage, but in any event, it's the direct result of the defendant just walking away from this contract and saying they're not going to do business. Everybody recognized in advance that this was part of the strategy, that the OIC business would be used to leverage and build more non-OIC business. We say the actual rule is that all loss is recoverable if it's the natural result of the wrong. But more importantly, what has this got to do with certainty? The question here is about whether or not it was certain this loss was suffered. The question about indirect loss, some exclusionary rule on that basis, it's got nothing to do with the ground of appeal, which you see on page 100. I don't know if I took you to it. Ground 3.2. The learned judge erred in law in fact in the application of law to the facts and was wrong not to find, 3.2, any non-OIC losses were too uncertain to form the basis of any award of damages. So it's got nothing to do with whether or not it's direct or indirect, nothing to do with the grounds. So there's no, again, these are just factual appeals. These are attempts to overturn your findings. That is it in terms of grounds 2 and 3. You should not be tempted to signal that you have such doubt in your own fact-finding abilities that some judges might find that you will have a real prospect of finding that you were out of your mind when you made those conclusions. Then we get to ground 4, which is the 51% point. We do say this is hopeless. So the argument goes that damages should be reduced because of the shareholding of the claimant, and that somehow, if 51% of the claimant's shares were held by another party, the claimant's profits would be reduced by 51%. That is incoherent as an assertion of law. The status of the company's shareholders can never affect its profits and losses. It's entirely irrelevant to that conclusion. It's a separate and distinct entity from its shareholders. Now, clearly there are shareholders whose fortunes will depend on how many shares they hold and whether they have hold those shares and all the rest. And some of those shareholders are associated with the claimant and the defendant. And so parties associated with the parties to these proceedings will be affected by the question of who owns the shares. But that is not the question. The question is whether or not the claimant has suffered the losses that Your Excellency found, and whether or not its profits and losses can be somehow affected by this. 3 points are raised on this. I touched on them very, very briefly. This will take me no more than 2 minutes. The first point that is made, this is paragraph 61. It said Synergize, which is the associated OIC company, would probably have taken over 51% of the shares. And so that's the counterfactual. But that's irrelevant because the issue of law is whether or not, if that happened, it would affect the claimant's profits. And of course it would not. The second point that's made is, well, you have to take into account that had that happened, profits would have been distributed to the shareholders such that Synergize would have got 51% of them. And the first answer to that is not even true. Companies don't distribute all of their profits, and whether or not what they distribute is a question of fact. But that is all beside the point. Dividends issued by companies to their shareholders do not affect their profits. I mean, I'm astonished that anyone would suggest otherwise, because what you do is you find out how much profit the company has made. That is the company's profit, and then you distribute it to the shareholders. But just consider if the defendant was right about this. So what they say is, well, you have to take into account distribution of dividends to shareholders in assessing the profit. Well, if you and you have to assume that all profits will be distributed as dividends. The logical conclusion of that is that no company anywhere can ever make any profit, because every company's got shareholders. And so if you take into account the distribution of dividends and that's all the profits, then there's no profits left. And then the third is, it said that this leaves the claimant with a windfall. And that is logically wrong, because it's not the claimant that gets a windfall. If the position had been that Synergize had owned 51%, the claimant would still make the profit that Your Excellency has found it made. And where those profits get distributed to the shareholders is in the interests of the shareholders, not in the interests of the claimant. And the bottom line of all of this is that Synergize, a party which is not party to these proceedings, a third party to this action, Synergize had the right, had the option to acquire 51% of the shares of the claimant. And it wrongly assumed that this litigation would have no value, presumably, and it made a bad decision as to whether to exercise its shareholding option. Now, that is got nothing to do with the claimant. If it's all about equity and what's fair, well, that Synergize's choices, commercial choices. But in any event, Synergize is not the party. Neither is the other shareholder of the claimant. The party is the claimant. And if the result is that the claimant's current shareholder has more shares than it would have had if the contract had gone ahead, even if that was an unfair result, and we don't agree with that, well, that doesn't affect the profit that the claimant would have made. It doesn't affect the profit that the claimant would have lost. It's about somebody else's fortunes, about the shareholders' fortunes. So we do say that there's just nothing in that ground whatsoever. I won't talk about costs because those just flow from the other grounds. So unless there's anything that you would like me to address any further, that's all I have to say.
No, thank you. I don't think I have anything. How long do we need for reply, Sir Timothy?
Your Excellency, I'm aware of the time in Dubai. I expect I will be up to 15 minutes, but no longer.
Yeah,
so I'm in
fine.
Your Excellency's hands.
No, we can continue.
Grateful. Thank you. I will be as swift as I can. The first point is that my learned friend relied on a suggestion in the context of the nullity argument that the case that we're raising is in essence a suggestion that there's been some fraud, and then as a result of that it's said that this is not therefore a question of law or interpretation which can go up to the Court of Appeal. Now the first point we say is this is the first time that this point's been raised. My learned friend was quite keen on saying that in a repeated sense in terms of my submissions, but it applies equally in terms of his. But the fundamental point is that makes no difference because it doesn't detract from the point that all that one is looking at in the context of my argument on nullity is the side agreement and the waiver letter. It's the meaning of the letter, it's the meaning of the side agreement that is the subject of the point of appeal. So it is a point of interpretation, just in the way that my learned friend's appeal on 3 years versus 4 years is. And I took the court yesterday to the case of Hudson and Hathaway, paragraph 37 of that. It's at page 1265 of the bundle. And there, in that passage that I took the court to, it's confirmed, this is Lord Justice Lewison's judgment, that the argument depends on the legal effects of the relevant emails, which is a question of law. Now that's the same as the legal effects of the side agreement, that's the same as the legal effects of the waiver letter. So we say that point is a bad point. The second point which I make, which is an overall point, and Your Excellency as a very experienced judge will obviously be alive to this and astute already, is that, of course, what's important is the arguments that I made and the way that I made those arguments. And I'm afraid that Mr. Montague-Smith on occasion had a tendency to mischaracterize my arguments or set up something of a straw man. It is the arguments that I made that, of course, are the ones that matter. Third, I'm also rather confused by Mr. Montague-Smith's suggestion that I was claiming that the side agreement was itself a sham. If there's any doubt on that, clarifying, I am not saying that the side agreement is a sham. I am saying that the side agreement renders the company contract a sham. The point on clause 24 is simply that I say that what is said there as to it not being regarded as an actual contract is outweighed by all of the other points, the 10 points I made on the document itself. So I'm saying when one looks at it and one looks at the nature of that document, clause 24 doesn't outweigh the rest of it. Clause 24 does itself appear to accept on its face clearly that what is being done is an attempt to render the company contract a sham. Third, it said that the de facto company point answers the entire case, but we say it does not. The case I took Your Excellency to earlier, case Dubai Court of Cassation case 330 of 2000, shows that the de facto company is used to pay its debts. In reality, of course, it's a way to get to the partners underneath. And as I said, it obviously makes sense that third parties who have liabilities are not punished by the wrongdoing of the company, but third parties who are creditors, who are able to claim from the company, are able to, and that is what we say the de facto company does. Of course, as I mentioned, the de facto company only arises if it comes under the latter act, not the 1985 Act. My learned friend suggested that the clauses of the side agreement were boilerplate clauses, and so they ought not to be given much weight. Your Excellency, there's no evidence for that at all. It wasn't something that was suggested in the evidence below. There's nothing my learned friend can point to. You need to read the contract, we say, on its own terms, and its own terms make clear it is intended to be binding. My learned friend made a point on the strangeness, he said, of the nullity rule. But again, we say it's not at all strange that if a company offends public policy, that it ends up as a nullity. We say that that is the clear result of the rule, and Your Excellency accepted that a breach of the profit rule or the share ownership rule would result in its nullity. So we say there's nothing odd about the rule at all. And the suggestion that because the company is involved in this case is the answer rather presumes the answer to the very question that this court is being asked to decide. Onto the ticking off, which Mr. Montague-Smith tried to mete out. I'm afraid he was on quite shaky ground. I'm afraid I do still say that the future loss or the future binding point is A, a bad point, but B, not as I understood it, Your Excellency's point. Your Excellency's point, as I understood it, is at page 9 of the PTA bundle, paragraph 13. And the point that I understood to be made in the judgment is that while in the side agreement provision was made for Mr. Helly to waive his profits, that does not, in my judgment itself, amount to a waiver of the profits or an exclusion from them. The side agreement even provided for the consequences if Mr. Helly did not waive his profits, and then goes on to provide for the triple damages point. This follows on from a finding that the side agreement was not binding. Clearly, we say Your Excellency's judgment was that the side agreement was not binding, therefore it did not provide for the profits, for the ownership or the profits to be waived. And insofar as the profits were waived, there was a provision which should be addressed by a fixed lump sum. We, of course, did address that point because we said that the primary obligation continues. The point about whether a waiver in the future is or is not binding was my learned friend's point, and I'm afraid to say I do still think that is a very bad point, and it's a bad point because what Mr. Helly was doing was agreeing to bind himself as to what would happen with the profits. The alternative would be, on my learned friend's case, that what needs to be done is every time profit is generated, Mr. Helly needs to make a separate retrospective agreement to waive that profit. And that is not necessary. Clearly, an agreement to bind yourself in future as to what to do with profit is enough. So I'm afraid that I say there is nothing in it. And I think it was unfair of my learned friend to try and foist that point on Your Excellency. We also say my learned friend suggested that the point about the waiver letter was not run at trial. But it was, and very clearly, and one can see if one goes to page 364 of the bundle, that's my skeleton argument and Mr. Reed's skeleton argument for trial at 53.7. One of the points that we rely on in the context of nullity is the waiver letter of the 7th of April 2014, and we quote from it there. Also, we say that this is, as we've said before, simply the interpretation of a document. It's the interpretation of what that waiver letter means. It is eminently suitable for consideration on appeal. Next, my learned friend made a point that the preamble ought to be disregarded, presumably because my learned friend saw some force in the point of what the preamble said. However, if one looks at the contract itself at 292, and this is a point I made in my submissions at clause 1, it does say that the preamble of the current agreement shall be deemed as an integral part thereof and shall be read therewith. So clearly it's being incorporated into the operative clauses of the contract. I'm grateful to my learned friend for his confirmation that there are no differences in translation between the judgments. He nevertheless suggested that one needs to be careful about the language in determining whether the agreement is binding or not. But frankly, that point falls rather flat if my learned friend can't actually point to anything which he says makes any difference to the quality of my submission And my submissions were simply that if one reads the document in either translation, it's clear it was intended to be a binding agreement. My learned friend also said that the agreement can be distinguished because it says it differs from the company contract. But we say that that doesn't mean that it's therefore intended to not be part of the company contract or not amend the company contract. It's simply realizing that the parties' obligations as set out in the HELU agreement are different from those in the company contract. And that, of course, is a necessary ingredient in order for the sham of the company contract to be revealed. My learned friend made some submissions entirely unburdened, we say, by reference to anything in the authorities, that what happens in a liquidation under a de facto company is getting the company's rights in. But we say it is significant that there are no cases that my learned friend has been able to point to where a company, a de facto company that has been declared null, has made a claim on third-party contracts. But the cases that we have seen, and the case that I took Your Excellency to earlier, shows that in fact that it's the other way, and that de facto companies can be claimed against. And as we've said, that of course makes sense in the public policy framework of the rule. My learned friend relied on the fact that in the Dubai Court of Cassation case 585/2023, that the company in that case was able to bring a claim, and says that this suggests that a company can bring a claim. However, there is, we say, a marked difference and a big difference between a company being able to bring a claim concerned with its own validity and status, and a company being able to claim on a third-party contract in order to bring in the rights that it says are owed to it under that contract. And we say that is an important difference, and that's why we say the fact that the company that was declared null in the proceedings on the arbitration dispute is not analogous to this situation and provides no authority for suggesting a de facto company can positively claim. My learned friend rightly said that the fact that the law has changed is not a point for today. But even if it were a point for today, we say my learned friend is wrong on that. We have already dealt with this at trial. Page 365 of the permission to appeal bundle is our skeleton for opening, and footnote 54 at the bottom of that page deals with the point. It's also, I think, mentioned in the Cafe Rider case as well as to which law applies, and it's the law at the point of purported incorporation of the company that is relevant, not the law at the time of its declaration of invalidity. And that's, of course, consistent with the fact that the UAE case law shows that what a declaration of nullity does is reveal what was always the case, i.e. that the company is null and void. It cannot spring up again if it was never valid in the first place. So turning then very briefly to certainty, my learned friend spent some time on appeals of findings of fact. We don't dispute that those are the principles on appeals of findings of fact, but we do dispute that our case on this should be classified as an appeal of the finding of fact. It is not. It is, we say, a question of whether the application of the legal test was wrong to the facts as you found them. We are not challenging the facts as you found them. Finally, we say as well on certainty that in terms of the question of indirect loss and what is recoverable, that is clearly a point of law. That is within the question of whether damages should be awarded as certain or not. And we say that generally there is a point of law, and that is what Al-Sanhuri was referring to, that indirect loss, and this is clearly indirect loss because it is not the loss that would have been recoverable from OIC, it is profit that is said to have been recoverable from other companies as a result of OIC's breach. So it is, Your Excellency may remember this came up in the trial at first instance, that difference between when one is kicked out of a flat and one has to pay a higher rent, which is direct loss, but then injury from bed bugs or the like, which is indirect loss. And that's the example given in Al-Sanhuri. We say this is indirect loss. That is a clear point of law. That is something that the appeal court can deal with. And then finally on the 51% reduction, Of course, Your Excellency will need no reminding, but my learned friend protesting that this case is hopeless is not the same as it in fact being hopeless. And we do say that the fact that Your Excellency found the result as not untroubling rather suggests that it is not as hopeless as Mr. Montague-Smith refers to. My learned friend looks at company law and the status of companies, shareholders, and the like, and the effect that has on profits, but that we say looks at it the wrong way. The right way to look at it is what is the counterfactual in which GLOBEMED would have been earning profit? And as Your Excellency found, that counterfactual necessarily includes 51% ownership by Synergized. That ownership was for the purpose of OIC taking a benefit in the profit. So the only circumstances in which GMG would have been earning profit are circumstances in which 51% of it would not have been kept by it. So as I said in my original submissions, this is simply a case where one looks at this in the same way as one looks at savings that would have been avoided. One looks at this as profit that would not have been kept. And we say that is, again, a point of law, a short point of law, an open question on which we have at least a real prospect of success. Your Excellency, I think I just about managed that within the 15 minutes, but are there any further questions?
No, I don't have anything. So I'd like to thank you, both of you, for today's hearing, and I'll try my best to come up with my position on this permission to appeal for both parties. Appreciate it. Thank you.
Thank you very much, Your Excellency. Thank you, everyone.
Thank you, Your Excellency.